My name is Nicolas Angelet. I'm from Université de Bruxelles, and also, I should say, one more member of the gang of alumni of this university. Very happy to be here to chair the panel on commercial practices and domestic litigation regarding secondary sanctions. So, I think we've seen yesterday, with notably the presentation by Mr. Vogt from Deutsche Bank, and also the presentation from Professor Emmenegger, how difficult it is for corporations to navigate or to try and evade primary and even more so secondary sanctions. If there were a humanitarian law of economic warfare, obviously some corporations would come as war criminals, but most of them come as civilians to be protected. And it is clear enough that many of them will turn out to be victims of collateral damage, and some of them will just come as cannon fodder. And so it's very difficult for corporations to abide by secondary sanctions while keeping their operations going. And that is where the legal profession comes in, private practice, in-house counsel. And this is very much what the panel is about. From a sociological perspective, I would say that the topic of the panel is commercial practices and domestic litigation. But from a sociological perspective, it is also about the legal profession, private practice. What do private practitioners and in-house counsel do when they face primary or secondary sanctions? How do they assist their clients? And so we have a marvelous panel of practitioners. The first one, who was supposed to be here, was Marie-José van der Heyden from Deloitte in the Netherlands. Unfortunately, Mrs. van der Heyden cannot make it today for imperative family reasons. She has asked me to convey her regrets and her apologies. And so this allows us to move forward to the first speaker, Maya Lester QC. Maya Lester QC is a barrister and Queen's Counsel practicing from Brick Courts Chambers in London. And she is a member of the Bar of England, and luckily for her, but mostly for us on the continent, also of the Bar of Ireland. And this will enable her to continue her absolutely stellar practice in the field of sanctions. Just to give you one example, Maya Lester QC acted as counsel in the case known to all of you as Cadi number 2. Maya Lester, the floor is yours. Thank you very much.
Thank you very much indeed for such a generous introduction, and I'm very sorry to be sitting in cold, miserable London instead of joining you in your beautiful city, and it looks like a wonderful venue. So just to introduce myself, I have quite a wide-ranging sanctions practice, and so the topic that I've been asked to speak to really interests me because of the diversity of sanctions problems that arise in a legal context. And I'll explain why I think secondary sanctions and the concept of mandatory provisions is particularly interesting, and not just of academic concern, but of real concern to the practical problems that arise. I also have, with a colleague of mine, a blog, www.europeansanctions.com, which we update several times daily, and there are free updates available to anyone who wants to put their email address in. And that really just shows you the extremely fast-moving, dynamic nature of sanctions. There are things happening around the world all the time, as everyone, I suspect, in this conference will know. So the topic I want to speak about just for a few minutes, and I very much hope that this is the starting point for discussion rather than a sort of lecture, because I'd be fascinated by everyone's perspectives here. The topic is really, how have courts dealt with the problem of secondary sanctions? And what I mean by the problem of secondary sanctions is that secondary sanctions, and I know much of the discussion yesterday, which I was very sorry not to have been able to attend, will no doubt have focused on some of the issues I want to raise. But in common with other forms of sanctions, secondary sanctions are a foreign policy tool. Now, that's a very obvious thing to say, but it's really important because secondary sanctions in particular are an extremely powerful tool of US foreign policy, but they are tools of foreign policy that have legal ramifications and very real legal implications, particularly in the case of secondary sanctions, because the consequence of having secondary sanctions imposed are very legal ones, potentially being added to the SDN list, potentially being cut off from banking relationships. Those are obviously highly significant legal ramifications. But these are particularly problematic kinds of sanctions legally. Why do I say that? Well, they pose many problems, some of which were alluded to yesterday. One, most obviously, is that they are a funny species of sanctions because they don't directly prohibit, forbid any kind of conduct. Why not? Because they can't. So what the US is doing is saying, if you engage in certain conduct around the world, we may assess that you have facilitated a significant transaction with a US SDN or whatever the wording is. We may assess that you have done that. And if so, we the US may impose consequences on your conduct. They don't say, because they couldn't, because there's no jurisdictional link, they don't say you may not enter into the following kinds of contract. So they're not directly a prohibition because they can't be. And that leads to the second sort of curiosity, which is that you can have a big argument about whether they are truly extraterritorial or not. And again, I think this arose a bit in yesterday's discussions, because yes, of course, they are extraterritorial in the sense that they have a worldwide effect of an extremely significant nature. But the US, on one view, is simply imposing requirements on US persons. In other words, in the US, you won't be able to have banking relationships. You may be treated as a US SDN. What they can't do, of course, is say that we, the US, will prohibit you in the United Kingdom or Belgium or anywhere else from entering into a transaction, because the US wouldn't have power to do that. So they are sort of extraterritorial and sort of not extraterritorial. And you, depending on your definition, and you can see that tracked in the big debates and controversy about secondary sanctions. Another legal problem, and again, really just by way of introduction to this area, is that some secondary sanctions are labeled mandatory, but they are only mandatory in a very particular sense. And this becomes very significant legally because some of the legal issues arising out of secondary sanctions have centered around whether they are, in inverted commas, mandatory provisions of law or not. And that is relevant to certain different legal questions. And one of the things that's always said is, well, if you look at the heading in the statute book in the US, some of them are called mandatory, and therefore they're mandatory. They are mandatory in a sense which is very related to US politics, namely the well-known battle between the executive branch and Congress when it comes to the imposition of sanctions. So some US secondary sanctions, notably CAT's Russian sanctions, were put by Congress on a mandatory footing when it came to Russia, because the assessment was that there was a danger that President Trump might, for policy reasons, not enforce them. And therefore, the mandatory aspect is that if there is an assessment by OFAC that the transaction is, say, facilitating a significant transaction with a US STN, then secondary sanctions must be imposed, not may be imposed, but subject again to a waiver for national security reasons. So they are mandatory in a sense, but only one sense only. And again, that's another area that's caused problems for courts looking at these. Now, finally, by way of introduction, it's relevant to this debate, two very practical concerns. One, that secondary sanctions, as Martin, I'm sure, pointed out yesterday, are extremely significant from a banking perspective and from the perspective of impacting on the behavior of international commerce. But they are very rarely, in fact, imposed and enforced. So they are, if you like, a very terrifying foreign policy tool, but imposed rarely. Now, that impacts on the question courts have sometimes have to look at, which is there a genuine fear that secondary sanctions will be imposed here? What sort of levels of risk of enforcement of secondary sanctions must there have to be in certain legal situations? Must there be a real risk? And if so, how does one assess that in a context where it's difficult to give comfort to a client that secondary sanctions won't be imposed because the wording of them often is so great and gives so much discretion to the US, and yet in practice, they've only been imposed in a few cases, and really where there've been fairly egregious, repeated knowing violations, and with quite a lot of warning from OFAC. And secondly, along the same theme, it's been legally relevant that it's very difficult to get any sort of comfort from the US authorities as to whether secondary sanctions will be imposed in any given situation. So unlike in the case of many primary sanctions, one can't apply to OFAC for a license or apply for a sort of comfort letter and say, could you confirm that if we, the bank, engage in the following transaction that we won't have secondary sanctions imposed? Now, there are some contexts in which OFAC will give some response to that question. And if anyone has practical experience of that here, it'd be extremely helpful to know it. But certainly there is no sort of published policy that anyone internationally can get any sort of view from OFAC about whether this is a situation that will engage a secondary sanctions risk. Why not? No doubt, because it's part of the foreign policy tool that this is a genuine risk and a threat which can't be comforted away. But that again has been part of the legal conundrum. So how does this play out in different legal situations in national courts? Well, what's interesting is that, as I said at the beginning, the very wide range of situations in which these sorts of puzzles that I have outlined have been relevant. So the first kind of context is contracts and contract cases, litigation, arbitration, advice. Because one issue that comes up a lot is, for example, when does non-payment or non-performance under a contract trigger certain contract clauses, such as a force majeure clause? So let's say a party to a contract doesn't make payment because of a fear of secondary sanctions. Courts have had a look at to what extent does that result in force majeure, and to what extent does it not? And so that is one of the areas that has preoccupied the courts. Now, there was a decision of the Dutch courts in April 2020 about a company called Pipe Survey, which raised just this issue. And without going into the facts or the detail, the view that that court took in that context was that the US secondary sanctions with which the non-paying party was worried didn't make performance of the contract impossible. Of course, they made it risky, and therefore the sort of negative, the fear of secondary sanctions did not amount to force majeure for the purposes of a contract. So that's one of those contractual issues. Now, another is, of course, the interpretation of contracts more generally. So, for example, when contracts talk about mandatory provisions of law, when is non-payment because of a concern about secondary sanctions, when might that be non-payment because of a mandatory provision of law? And I'm going to come back to that in a moment. Another legal context is, what about all the cases which say, and indeed the various international conventions that say, that parties can't contract out of or derogate from mandatory provisions of law? Now, are secondary sanctions mandatory provisions of law for the purposes of that kind of situation? Given that, as I've said at the outset, they're only mandatory in a certain kind of sense of the word. They are not sort of directly applicable, and they don't directly prohibit any contract. So again, that's come up in many contexts, and I'll come back to that. Thirdly, what about the situation where arbitration awards in particular are not enforced because they are contrary to public policy, international public policy? Now, this will be an area familiar to some of you. Are US secondary sanctions for those purposes contrary to public policy, or are they not? Because some countries in particular, the EU, the United Kingdom, a number of others are opposed to the sort of principle of extraterritorial long arm reach of US law. And therefore, are they part of the same sort of public policy, or are our public policies in fact running head to head in this area, particularly given the presence of the blocking regulation, which I know, again, we're coming back to, and it's wonderful to have the Commission here talking about that. Now, the sort of final context I wanted to talk about before coming on to another couple of cases and then closing is indeed the blocking regulation, because courts have considered, both national courts and the Court of Justice have considered and are considering the relevance of the blocking regulation in this context. So for those of you who don't know, which is probably no one here, what the EU blocking regulation and indeed the UK's post-Brexit version seek to do is to try to make complying with some US extraterritorial laws unlawful in the EU or the UK. So that has created a number of legal difficulties of interpretation, not least because a number of provisions of the blocking regulation are unclear. So they are particularly unclear in the context of US secondary sanctions, it seems to me. Just a few of the questions that are raised. What does the blocking regulation mean when it refers to it being unlawful to comply with a prohibition or a requirement in the laws in the annex? Does that apply to secondary sanctions, given that, as I said at the beginning, they don't contain any what we would traditionally in law describe as prohibitions or requirements because they can't? Now, does the blocking regulation attach to the whole of the laws in the annex or just the extracts in the annex? Now, there are some secondary sanctions among those annex, but some primary sanctions. So is the blocking regulation intended to relate even to secondary sanctions? Seems like an obvious question because it refers to extraterritorial laws. So is by extraterritorial laws mean secondary sanctions, even given that on one view they're not strictly extraterritorial? So even the laws to which it applies, I think, is up for argument. What are the remedies available, and so on, and that some of those questions will be, I hope, clarified by the Court of Justice at some point in some of the preliminary references that have been asked by national courts. I'm mindful of the time, but I wanted to talk about a couple of cases. One final point about the blocking regulation before I do that. Not only is there an issue about when one can meaningfully be said to be complying with a prohibition, where it's the blocking, where it's US secondary sanctions we're talking about. Another is the extent to which there needs to be some kind of decision, legal decision finding a breach for the blocking regulation to apply. And that and some other questions have been answered at least by the advocate, the Irish Advocate General in the Mellybank case in the Court of Justice. One of the cases I wanted to talk about is one I lost, which is not the only reason I want to talk about it, but I think it's the one I know of, but would be really grateful to hear from the panelists if they know of others, which most directly grapples with some of these legal problems that I've been introducing. And it's the Lemessa and Synergy judgment of the English Court of Appeal in June 2020. Now, what happened in that case, it's relatively straightforward on the facts. So there was a banking contract, which is really a standard banking contract, and therefore this case is relevant to banking contracts across the world because the same wording applies in so many of them, which effectively said that a party would not be in default under the contract if it didn't make payment that it owed. But the reason it didn't make payment was in order to comply with a mandatory provision of law. And on the facts of this case, the bank didn't want to make interest payments that were owing to a Victor Vexelberg subsidiary, Lemessa, which was blocked under US sanctions, because of the concern about CATSA secondary sanctions. In other words, because if it was judged by OFAC to be facilitating a significant transaction with the US SDN, then there would be a risk that secondary sanctions would be imposed. And so the arguments were, you know, was that a non-payment because of concern about a mandatory provision of law, or is that not mandatory in any meaningful sense of the word? Because, as I said at the outset, there is no direct legal prohibition. There is more a sort of warning that if you engage in certain conduct that we assess to be facilitating a transaction with the US SDN, then we may or must impose secondary sanctions. Now, interestingly, and you can think yourself about whether this is right or wrong, the court said that those were mandatory provisions of law. And the reasons it gave are quite interesting. It said, although on the plain language, secondary sanctions don't directly prohibit anything because they can't, they are what the Court of Appeal described as an effective prohibition, basically because they have such a practical impact and such a chilling effect on the ability of parties to enter into commercial transactions. And the court was guided in that view that they were mandatory provisions by the fact that the EU blocking regulation uses the language of prohibition and complying with a prohibition, and the blocking regulation, as I've said, annexes some US secondary sanctions. So the court basically said, in order to make some sense of the blocking regulation, it must mean that secondary sanctions are in some sense prohibitive, and therefore non-payment because of concern about secondary sanctions does indeed mean the party isn't in default because they are not paying in order to comply with a mandatory provision of law. Now, it seems to me, but then I would say that, being on the losing side of this argument, it seems to me strange to use the fact that the blocking regulation does that to interpret an English law contract. It seems to me, but I realize I may be a lone voice here, that the more likely interpretation is that the blocking regulation is quite unclear about a number of these issues, including whether it does sensibly apply to secondary sanctions and in what sense it does. And it seems to me to be a strange result to say that fear of secondary sanctions could be non-payment because of a mandatory provision, because what it means is certainly, it seems to me, there is now much greater reliance in a contract context on fear of secondary sanctions as being a legitimate reason for non-payment in a context, as I've said, of very low enforcement rates and so on. And of course, all of this would be somewhat ameliorated if there were some system of getting some kind of comfort from OFAC. Just sort of finally, a couple of other cases to mention. I've mentioned the Dutch case suggesting that US secondary sanctions don't make a contract impossible to perform. It's also worth mentioning a very interesting Swiss case in December 2020. A lot of these cases happened in 2020, I guess, because of the CATSA fallout, which was sort of the opposite result to La Mesa in a sense, where the Zurich Commercial Court refused an application by La Mesa, the same company, to require a bank to process a payment. And what the court there held is that you can't require a bank by an injunction to process a transaction with La Mesa. It's entitled not to do so because of a fear about concern of secondary sanctions. And so again, there's an interesting legal issue about, obviously it seems to me to be different to be requiring banks to engage in transactions as opposed to permitting parties to rely on contract clauses as a result of secondary sanctions. Finally, a case on a French case this time on the issue I mentioned of whether secondary sanctions are part of international public policy such that arbitration awards shouldn't be enforced if they create a secondary sanctions risk. And the French, commercial chamber of the Court of Appeal in Paris, in a case called SAT and Société Nationale, I think it's called, in June 2020, interestingly said that US secondary sanctions are not part of French or international public policy because, as I've said, of the sort of opposition of France, of the EU, of member states, of the UK, to the whole idea of having extraterritorial secondary sanctions. And therefore they rejected the argument that the arbitration award in that case should not be enforced because of the risk that secondary sanctions would be imposed. So I'm going to leave it there. It's quite difficult to summarize these cases in a clear way because they are so sort of fact sensitive and legally complex. But I hope that's at least given an idea for the purposes of discussion of the complexity and diversity of this area. So thank you very much, and I look forward to some discussion.
Thank you very much indeed for this very interesting presentation. I don't know if someone in the audience or online would like to ask questions now, or shall we perhaps proceed with the next speaker and then have a broader discussion? Perhaps that would be more appropriate. Do I have a question? Is that what you are indicating, Tom?
I see some hands being raised by the online.
Okay, yes, thank you so much. Yes, Professor Ebenegger, perhaps.
I'm trying to get, okay. Thank you so much, Malia, for this wonderful presentation, and we need to get in touch. Victor Vexelberg had a very bad year this year. The Supreme Court confirmed the Zurich Court's decision, but he also had another, he has no more bank accounts in Switzerland, basically, even though he lives here. There's no bank wants to service him. Even the Swiss Postal Bank was supposed to service all people who have a residence here, and the argument was that it is too cumbersome for the Swiss Postal Bank to service him as a client, and they even changed an ordinance a la Vexelberg to sort of be able to exclude him. So I think your cases are very interested, and I just want to make sure that that maybe we exchange these cases, because I'm a contracts law person and I'm very interested in that. And just as a thought, it's interesting that the courts for the sanctions now are moving in that direction, because we had a similar issue with tax issues. American citizens having accounts in Switzerland non-declared, and the banks refused to pay them out for fear that they would be prosecuted in the States. Many of them had even a deferred prosecution agreement, and there the courts protected the clients and no, this is not applicable here. You have to pay it out. And with the Vexelberg case, and it's not the only one, they are saying, well, it's not really applicable. As you say, it's very complex always, but they always find other ways. And in the Zurich court, it was the general terms of the contract. Well, the contract has general terms, and they agreed to stop any payment. And since we don't have a review of these standard contract terms, because we basically have no consumer protection in Switzerland, the courts could just base it on this. But this is just a very brief response. And if anybody knows of any contract cases, I'm very happy to receive notice. Thank you.
That's fascinating, and thank you so much for that comment. I've also noticed in the chat that there's a comment which in some sense reflects what you've said, that the European courts help the US Congress as the main driver of secondary sanctions. And what's interesting, I suppose, is that, yes, you could say that the more the courts take the view that secondary sanctions should or can legitimately have these very far-reaching implications, you could say that those judgments in some sense are giving more power even to secondary sanctions. But it's difficult for courts. I mean, also it's a sort of not a very legal observation, is that sometimes, very often, the courts, certainly that I've spoken to, are not that familiar with sanctions often. And so I think there is a bit of a different attitude to secondary sanctions legislation by a non-specialist. I don't mean that to sound patronizing, but if you don't know anything about sanctions and you read them, you might be tempted to give them an effect that perhaps those who are actually, night and day living with the consequences of secondary sanctions may take a different view. But that's, I don't know, out there for discussion.
Maybe a last point on this. What's also not helping is that bank supervisors are helping too, because, for instance, the Swiss supervisors sanctioned BNP Paribas and other Swiss banks who violated sanctions and said, you don't have a good risk management. So they actually sanctioned them on this basis. They didn't say secondary sanctions are applicable, but they said, well, if you violate foreign laws, well, your risk management is not up to the task. And so that again adds to the weight of secondary sanctions on a private law level.
Indeed. And also a sort of final twist to that is an area that is not much discussed, I think, as a practical, maybe rather than a sort of academic legal conference one, is the extent to which there are some banks who don't care so much about the US secondary sanctions risk. And there'll be an interesting question about, parts of the world where actually banks are less dependent on the dollar, because after all, the extreme extraterritorial impact that these sanctions have is there, in my view, not so much because US law exceeds a territorial idea of jurisdiction, but more because we're all so dependent on the dollar that is why they are such a terrifying foreign policy tool.
Thank you very much. Other questions? No, then perhaps we will move forward with the next presentation, which is by R.Dura. Robert, thank you for joining us. Robert is a senior associate in, I believe, Washington, D.C.'s practice of Voice, well known to public international lawyers. And well, we are all happy to expand our knowledge of the firm by meeting Robert, who is in corporate practice, working on compliance, with an initial emphasis, I understand, on financial institutions, and now rapidly expanding as indeed the practice of sanctions expands to so many other fields. Robert will discuss a topic which I will really discover today together with you, which is sanctions in mergers and acquisitions. Thank you very much, Robert. You have the floor.
Thank you. First, I'd very much like to thank Nicholas for his moderation of the panel and Drs. Rees and Ringard for organizing this conference and the team that's supporting them. I'm very happy to be invited and speak today, although I am thoroughly disappointed that I'm unable to join you there in person. As Dr. Englert introduced, I'm going to be speaking today on U.S. secondary sanctions and M&A. Many of the topics I have planned in my remarks here have already been touched on very capably by Maya, I suspect, as well in many of the other panels. And in preparing these remarks, I thought I'd focus on a higher level discussion of the issues that hopefully can promote some questions and discussion with the audience in the panel. And what I'm trying to avoid as best I can is a very legalistic training session on the nuances and intricacies of the issues. So with that, I think first today, I'd like to speak briefly on the topic that's already been raised about sort of taxonomy or classification of sanctions from a practitioner's perspective. Perhaps some might be surprised by my view that secondary sanctions, at least in this context, are not that different than primary sanctions when distilled down to the relevant risks for a non-US company. Next, I'll look at similar implications of related risks on M&A, which I'll loosely define to include similar corporate activity, not only traditional acquisitions, but also things like entering into joint ventures and minority investments, as well as important supporting activities for M&A, particularly financing and insurance. As Maya already noted, and I'll touch on briefly, these third-party service providers, particularly in financial services, play an important gatekeeping role in the administration of US sanctions policy. Finally, I'll touch briefly on some measures that are widely used to address sanctions-related risks in this space, although I think our colleague on the panel, Mr. Kaiser, may be touching on sanctions clauses in more detail, so I'll limit my comments there. So what are secondary sanctions risks for an M&A practitioner? Well, as widely discussed in this conference, of course, we broadly divide US sanctions into two general categories. The first is our primary sanctions. And the way I describe these is that primary sanctions impose affirmative compliance obligations, the violation of which constitutes a breach of US law regulation, such that an administrative, civil, or criminal penalty may be imposed under US law and enforced by US courts on the breaching party. The second category covers a broad range of targeted activities that all carry a similar risk. Namely, that by engaging in the targeted action, a person could find itself becoming a target of US sanctions. For example, itself becoming an SDN. Often, as Maya and others have already discussed, we think of secondary sanctions as the US legislative sanctions, including things like CATSA, Countering America's Adversaries Through Sanctions Act, which focuses on sanctions against Russia. And there were some earlier ones too, like the Iran Threat Reduction and Syria Human Rights Act, and quite a few. And if I recall accurately, and as Maya also noted, it's these statutory sanctions that comprise the bulk of the measures set out in the annex to the EU's blocking statute. In addition to these, though, I also would include most of the presidential executive orders that provide the authorizations for most US sanctions programs. These executive orders set out the persons and activities that are targeted by US sanctions. In other words, like the statutory secondary sanctions, they set out essentially designation criteria. As one example, in Executive Order 14014, which I think might be the most recent authorization in this context, President Biden drew on standing authority provided by the International Emergency Economic Powers Act, or IEPA, as we often refer to it, to declare the military coup in Myanmar a national security and foreign policy threat to the United States. And in doing so, he authorized US sanctions against, among others, any persons determined to operate in Myanmar's defense sector or to have been responsible or complicit in certain human rights abuses there. The tie-in to secondary sanctions is that, like most other executive orders authorizing US sanctions, the order authorizes sanctions against any person determined to have materially assisted or supported a person designated under that order. This means that US authorities can designate any person doing business with a person already sanctioned under the order if they've determined that that business constitutes material assistance or support. For those familiar with the substance of secondary sanctions, including those Maya referenced, like Section 228 of CATSA, these risks should sound similar. Those statutory secondary sanctions typically have provisions that say something like any person that conducts a significant transaction for or on behalf of a US sanctioned person can itself be sanctioned. So from a non-US company's perspective, looking at these secondary sanctions, looking at the executive orders, the risks are substantively similar. Engaging in certain conduct will get you sanctioned by the United States. So what are the implications of this wide net of secondary sanctions for M&A activity? The primary implication, I think, and unsurprising to everybody here, and the reason why I think many of us are focused on this issue and participating in this conference, is that these secondary sanctions now raise meaningful risks for non-US companies. And as Maya noted, we can certainly and should discuss what meaningful means in this context. But I think it's fair to say that from their own perspectives, many non-US companies do view these risks as very meaningful. As a result, I think many cross-border deals, especially, it's probably less relevant in an entirely internal M&A context. But in many cross-border deals today, you would see some level of sanctions-related diligence of the target's activities. Sort of follow-on observations of that fairly prosaic observation there. I'd also note that sanctions have foreclosed important markets and suppliers to non-US companies. And there can be a tension between the clear and pressing business case for certain dealings targeted by secondary sanctions and the vague nature of the threat of secondary sanctions. In some cases, this can be a case where a sanctioned jurisdiction has a resource that a non-sanctioned person wants. This can include, obviously, like petroleum assets, particular types of petroleum assets. It can also involve business opportunities, a whole range of commercial activities. Additionally, I think it's also fair to observe that the risks of secondary sanctions, as Maya alluded to at the end of her comments, they do not fall equally on all non-US persons and non-US companies. There are, in this context, I think at least 3 drivers among non-US companies in their risk assessments regarding US secondary sanctions, at least as far as I've seen it in sort of my practical experience of counseling and being across the table from non-US companies and negotiating these topics. First, and probably the most important driver, are the company's touch points to the United States. If a company has operations that are wholly outside the United States and do not involve support or supplies from the United States, importantly, this includes financial services and the ability to clear US dollar transactions through a US correspondent bank. If non-US companies do not require those services, they may not face meaningful risks from designation by the United States. There are, of course, numerous examples of US sanctioned companies in Cuba, Iran, Russia, China, and other places that have successfully continued operations after being sanctioned by the United States. I think it's fair to say that these companies have are fairly insensitive to the US secondary sanctions risks. Second driver that I've seen, non-US companies face compliance pressures from their investors and their financial services providers to avoid certain dealings with US sanctioned persons. In some cases, these pressures are motivated by the third party's own legal obligations. Again, Maya went through a very nice illustration of how this can play out in the secondary sanction space, even among non-US banks. Another example where this frequently arises is in insurance, particularly things like P&C insurance under global policies. US insurers cannot provide cover for activities prohibited to them. And so they have found ways to still provide global cover to non-US companies while excluding prohibited activities from that cover. In other cases, the pressure from outside parties, often from investors, comes from a focus on maximizing the value of the non-US company. In recent years, I've worked with a wide range of institutional investors, from PE firms to sovereign wealth funds to state pension companies that have active investment arms, to assist their controlled companies to develop demonstrable sanctions compliance programs. This largely has two purposes. One is to avoid compliance issues at the company that would impact its value, its valuation. Penalties for violation of sanctions can be significant, and becoming subject to sanctions would obviously have a devastating impact on the value of a company. And the second motivating factor is avoiding valuations of the company that are supported by business dealings with US sanctioned persons. This also could significantly impact the valuation of the company because on sale or exit, the company likely would not be purchased by any US buyers, and few non-US buyers would also be interested. As a third driver, and perhaps already tangled into the first two that I noticed, non-US companies are often hesitant to engage in business targeted by secondary sanctions or with US sanctioned persons for fear of losing business opportunities. So for example, in assisting globally active companies to diligence a local partner if it wants to enter a market and do business, perhaps through a joint venture or similar structure, most globally active companies would avoid partnering with a local company that has dealings with US sanctioned persons, even if those dealings are outside of the proposed relationship and perfectly legal for the counterparty. This risk aversion may be motivated in part by compliance with US sanctions, but another important consideration that I sometimes see left to the side in discussions about US sanctions is that decisions to forego business that implicate US sanctions can also reflect sort of broader concerns with business reputation. Most persons targeted by US sanctions have, in the course of that targeting, been publicly alleged by US authorities to engage in highly problematic conduct. US authorities will present allegations, if not evidence, of human rights abuses, supporting terrorism, narcotics trafficking, significant corruption. Generally, the reasons why many people are subject to U.S. sanctions are very concerning from a business reputation perspective. And I'd say the minority of U.S. sanctions, although probably putting an asterisk next to that, are sort of more foreign policy, political, like some of the Russia sanctions. And in thinking about these drivers, and as many have already raised in this conference, there's of course the complicating considerations of blocking statutes. You know, how does a blocking statute in a local market affect your ability to consider options in an M&A context? If, for example, an outside partner in a JV goes into a local market and partners with a local partner, are commitments from that local partner to comply with certain restrictions imposed through contract, could those be meaningless essentially under local law? You know, these are all issues that ideally would be thought about in advance of tying up resources in an M&A venture. So how do we address these risks in M&A and related activities? The term of art or catchword in the industry is a risk-based approach. You know, at its most basic, this means it's a principles-based approach to managing risk, and it focuses first on promoting and ensuring an accurate and effective identification of the relevant risks. You know, it's hard to emphasize this point enough. And again, as Maya very well set up at the end, and without seeming to sort of speak down or be patronizing, these are complicated areas of law. The language of the statutes and of the sanctions authorities can be somewhat misleading on first reading. It often is drafted, particularly the statutory congressional sanctions, to evoke a sense of sort of mandatory obligations, when in fact that's not the case when you start drilling through it. But really understanding and having an expert to assist in the process to know where the jurisdictional limits are of primary sanctions, where the real practical risks lay in secondary sanctions, is an extremely important part of the risk-based approach to mitigating sanctions risks. The second half of this approach is, of course, designing and implementing the controls that will mitigate those risks that you've identified. These controls, the so-called risk-based approach, should be reasonably designed in light of the nature and context of the relevant risks. In general, this means that increasingly the practice has been that where actual sanctions risks are identified during negotiation of an agreement, the contractual controls that will be adopted now usually go far beyond sort of ordinary contractual defense, like force majeure or impossibility, and include very specific language that's been put into the agreement with the intent of sort of sidestepping or avoiding some of these common defenses and sort of counter defenses, and ensuring that the framework the parties put together to address the sanctions risks in the contract will be recognized by the relevant courts. Said differently, and summarizing that whole discussion, you know, higher risks generally demand more resource-intensive controls. So in lower risk activities, such as M&A activities entirely in the United States, Canada, or Western Europe, the deal diligence largely involves a questionnaire that gets sent across to the target, likely a conversation with management to run through some of those responses, and then an inclusion in the deal agreements of appropriate representations that the company being acquired is, of course, itself not a target of sanctions, and as negotiated, usually language about being in compliance with applicable sanctions, possibly some language about no dealings with sanctioned persons. In higher risk activities, the negotiation of the sanctions-related issues often is very central in the deal discussions, can occur very early in those discussions because it usually informs many core components of the deal, including valuation, available financing, post-deal operations, and sort of, if relevant, minority protections. So in asset share purchases, sort of traditional M&A context, the discussions likely would focus on representations and warranties that will be included in the agreement, and the related indemnities and other remedies that can be sort of evoked if the reps and warranties are violated. If there is a minority investment or a JV construct, something where my client participating in the M&A activity would have less than full control of the final entity, this often involves more effort. There can be bespoke contractual sanctions provisions that direct sort of identification of sanctions issues. For example, in entering the Russian market and increasingly sort of doing business with Chinese partners, they often push back against allowing one of the parties to an agreement to unilaterally invoke sanctions reasons for withholding performance. And they often look towards some third-party validation system to try to sort of manage the risks that their counterparty would be too risk-averse, would attempt to argue too broadly that sanctions apply in the context. And so this often is a considerable amount of discussion at the front end of the agreement. There also, of course, are the mitigating measures triggered once a sanctions issue has been identified. And again, this can involve a significant amount of discussion and negotiation, and is really focused on the particular details of the transaction. In some cases, we work very hard to carefully sort of carve out specific rights and obligations under the agreement for which performance can be withheld for sanctions-related reasons. In other cases, we find that sort of a full stop automatic suspension or termination of the contract is probably the best risk-based approach to go. And negotiating those and ensuring that the language works, and trying as best we can to ensure that a court would agree with us that the language works is, of course, the whole point of the exercise. Without hopefully stepping on the next presentation on sanctions clauses, if audience members are interested in seeing some sanctions clauses that are in use by market participants, these are ones that are designed in large part to address primary sanctions, but it can address secondary too. I'd point to the wording of Lloyd's Market Association and wording 3100. This is sort of a simple, straightforward sanctions exclusion clause for insurance contracts. I think it's very nice and very sophisticated in how it addresses secondary sanctions risks by referring not towards violations or obligations, but referring to exposure to sort of liabilities or consequences. The other discussion that is familiar in the financial context comes from the Loan Syndications and Trading Association, which publishes, has long published, a guidance document towards lending banks on how to think about their sanctions clauses such that the agreement would sort of comply with best practices and the loan could be sold after originated. The one topic that perhaps I would raise for further consideration, and not one that I'm prepared to speak about today, although one that keeps popping into my mind as particularly relevant, and one that has been sort of woefully unexplored in this space, is that as the EU considers revisions to its blocking statute, I see sort of very little discussion about a peculiarity in US law that is essentially also a blocking statute, and that's the longstanding US anti-boycott rules. There's a lot of parallels between the blocking statute, except of course that the US anti-boycott laws, while broadly written, are intended primarily to ensure that US companies don't comply with the Arab League boycott of Israel. It's interesting to see that these measures have been out for a long time, and that although the authorities are broad and similar, they really are discussed and come up as a practical matter in very different contexts. Certainly would be very interested if any of the scholars here had any further thoughts on how these structures work and these programs operate, because it's not entirely apparent to me as a practitioner how to make sense of all of this. I want to thank everyone for their time and attention to my remarks, and very much welcome questions and discussion on any of these points. Thank you.